Hello, and welcome to today's panel, hosted by the Council on Criminal Justice. Today, we're honored to present a Q&A with California's Chief Justice, followed by a panel of experts from court systems across the country. I'm Abby Walsh, the Council's Director, here with a few housekeeping notes before we begin our program. We are joined by nearly 600 participants today. To ensure a quality experience for everyone, all lines will be muted, but we do want to hear from you. So throughout today's session, you can submit questions using the Q&A box at the bottom of your screen, or email us at info@counciloncj.org at any time during this call. We have a packed agenda, but hope to turn to your questions before the end of our time. With that, I'm pleased to introduce John Tilley, Council Senior Fellow and former Secretary of Kentucky's Justice and Public Safety Cabinet. John, the floor is yours.
Well, thank you, Abby. Again, I'm John Tilley, a senior fellow at the council. And first, we'd like to say that we hope all of you are safe and well. So glad you've joined us today. As Abby said, we've hit our limit. Nearly 700 have registered. I know hundreds are on the call. And hopefully for many of you, this is the second time you've been on one of our calls. Last week, we were talking law enforcement. Today, the second in our series, COVID-19 and the criminal justice system in our courts. So today we'll talk about those challenges. And in case you're joining us for the first time, just a quick word about us, the Council. So the Council on Criminal Justice is an invitational membership organization, a think tank serving as a center of gravity for the field and policy. And our mission is to be guided by facts, evidence, and most of all, justice. To talk about those very principles of justice today, we have another distinguished panel of leaders, much like last week. This call is designed today to connect you, also leaders and important voices across the field, with one another. And tuning in, council board members and trustees, federal, state, and local officials, leaders, as we've said, from all across the spectrum, researchers, advocates, and the media as well. And so first up, we have the Chief, Council on Criminal Justice trustee, and the Chief Justice of the California Supreme Court, Tani Cantil-Sakauye. Thanks for joining, Chief. Let's get right to it. And by the way, her biography and the others I'll introduce today are linked to our event page. We couldn't possibly read those extensive and impressive resumes in the hour we have allotted, so please tune in and take a look at their biography. So back to you, Chief. Your governor has issued an emergency order in your state. We've talked a lot about that. So tell our listeners what that means for California and the criminal justice system.
Thank you, John. And I want to really thank the council for their good work and for having me. Well, previous to the governor's declaration delegating much authority to my council and myself, and also to enact any rule that may or may not interfere with any statute or law, therefore making the statute suspended, the California judiciary operated under individual emergency orders. And unlike many courts of my colleagues here today on the panel, the California judiciary is decentralized. We are individual courts. We are the largest judiciary in the United States. Confining my comments to trial courts and trial courts only, we have over 2,000 judicial officers, and our entire staff at the trial court level are unionized. And so we have 2,000 independently elected officials. And prior to the governor's emergency order, these judicial officers would appeal to me as the chair of the Judicial Council to ask for individual extensions of time under criminal law and civil law, family law, and welfare and institutions juvenile law. So before the governor actually gave his declaration, his order delegating authority to me and my council, I had signed over 100 different discrete sort of concierge orders for the various 58 counties to help them operate during the virus. The courts were all trying to shrink the people who come into court because they no longer had the judicial officers or the staff, and to focus on core critical justice issues. But in 58 counties, the judges themselves, based on their culture, differed as to what was a core cultural, important, urgent criminal justice matter. And so I was dealing with these emergency orders. The governor was getting requests from civil lawyers and from criminal lawyers and other justice stakeholders. And so in late March, he issued an unprecedented executive order delegating to me and my council the authority basically to act any rule under the furtherance of the COVID-19 virus to balance access to justice, and public safety in such a way that he gave us the authority to do any action necessary. And if any of our rules conflicted with law or statute, our rule would suspend the conflicting law. Now, to know a little bit about the import of that kind of order, you need to know a little bit about California, which differs from some of my colleagues. And that is, we have a judicial council that is a constitutional body that is like the board of directors for the California judiciary. And I'm its chair by order of the Constitution, and I name 31 of its members except for 4 lawyers. We meet as a body. We are responsible for the rules, the policy, the jury instructions, all the forms, and we back certain laws in the legislature. So when the governor tendered this delegation of authority to us on a temporary basis, we were, for the first time now, operating as 2 branches of government. The legislature in California is not in session. They are currently monitoring everything that's happening, and they're ready to act when they come back. But this became now a conversation between the executive branch and the judicial branch. So the governor delegated this authority. So now what this authority meant is, instead of 100 and counting now executive requests that I'm receiving from 58 trial courts multiple times, 5 a day, I'm now ordering through counsel, after deliberation and hearing from justice stakeholders, what we need. What does the criminal defense bar need? What do the prosecutors need? What are the sheriffs doing? What's family law? Where are our juveniles in dependency and in delinquency? And so we're making emergency rules, and we're making them according to basically a balance of the requests, a balance of justice, but trying to keep the crowds in our courthouses where 5 million cases are filed annually. We're trying to keep the crowds down to be in compliance with all of the social distancing orders.
That's excellent. Give us an example of what those orders mean to certain types of cases in the criminal justice system, to a defendant, to those who represent, both sides of that equation.
Well, one of my first orders, which was outside the governor's declaration, was in mid-March. Based on all of the requests I was receiving from the 58 trial courts, they could not assemble juries. They couldn't bring in 200 and 300 people at a time. I ended up using my constitutional authority based on this good cause request to suspend all jury trials in California for 60 days. Soon thereafter, the governor's authority allowed us to now act more independently and also more directly and quickly. So one of the first things we did was extend the time for which an in-custody defendant needs to be arraigned. We also did the same for when an in-custody defendant needs to have a preliminary hearing. We also extended times for when juveniles faced with wardships or delinquency matters and felonies and had to have hearings. We extended the time. Even though we extended the time, we told courts to act with great speed, but gave them an outline or the outer boundaries of which they could still act and still be within these emergency orders that basically suspended certain statutes that already indicated the time for certain accused. Additionally, we had set a 0 bail schedule for low-level felonies and all misdemeanors. And then we have a list of exceptions where the bail schedule still applies. We did this in part because we were not getting enough information from the jails and to their custody arrangements as to whether or not they were in fact exercising social distancing. They were bringing folks up the way that it's normally happens in California, like other states, shackled, 1 foot apart, crammed into rooms. And we have a skeletal staff of judges and court staff, and we were concerned about that interface. So we set a 0 bail schedule. And previously we had advised courts to go to a 0 bail schedule. We were hearing they weren't. So we went to a 0 bail schedule. We received public comment. As you might imagine, there was support and there was opposition. It's now currently in effect. We're monitoring that. But even though there's 0 bail being set for misdemeanors and low-level felonies, judges are still empowered to use their discretion. That is, to set conditions on release, to order appearances regularly, or to pretrial services or probation offices on release, as well as to simply deny the 0 bail schedule if they have good cause.
Excellent. So data obviously is important. Is there a set, or is there certain data you wish you had, or your trial judges are telling you they wish they had?
Yes. I think the biggest piece of data that we need is concerning our custody defendants, and our custody juveniles. That's what we're most concerned about, because that's where we are very careful about the timeframes and the rights, and because we want to balance health and welfare and release in these unprecedented times. So the greatest data that we would use if we had it is what is happening in real time in the jails. But the jails are understandably busy. The sheriffs have their hands full, not only on the streets, but at intake, and also because our governor also issued an executive order where he closed down prison intake. So normally jails move sentenced prisoners to state prison pursuant to the sentence. That's been halted. Additionally, our jails, after some laws that have passed a few years ago, are now places where they house and treat some mentally ill. Our jails, our sheriffs have their hands full. And so we understand that we have not been able to receive real-time evidence on what is the contagion in the jail. And so we've had to act preemptively and proactively. Wish we had that data. That data would help us maybe curtail and maybe in some way better massage and better limit our rules. But without them, we've had to act in that void. Additionally, we rely heavily on our presiding judges in our 58 counties, in our 58 superior courts, and we are getting real-time information from them as to what they need. And of course, we have judges and counties with 2 judges and 1,200 people. And then we have LA, which has, Los Angeles has 600 judges and 10 million people. But their needs have to be aligned in order for us to create a rule. So we need to hear from our stakeholders. We need to hear from all of the people who are affected by the justice system. And we're just not hearing from them kind of in the manner and in the promptness we need as we go to rulemaking.
Chief, I know that you have to run on us in just a minute, but maybe the last question, I think it would tee up the rest of our panel nicely, was if you could summarize maybe, and I know you've commented on this in some publications, the balance between public health, public safety, and justice, the rights of the defendant, Sixth Amendment rights. Could you summarize where you feel California is in a good place, you think?
I'd like to think we're in a good place. Our emergency rules only went into effect as of April 4th that really talked about curtailing or giving greater time for arraignments and greater time for preliminary hearing and our zero bail schedule. But we struck those kinds of balances, hoping that we were balancing first the defendant's right to justice and access to justice, but also his or her own public safety, safety in the jail. So that's why we went to video and remote arraignments, video preliminary hearings, video depots, video service, everything we can possibly do remotely, because we also don't want to endanger that person coming to court, and then of course everyone in court. So I think the question remains to be answered, but we continue to tweak and massage and change these rules as we find where they might be being applied egregiously. But at the same time, I think that we all understand, even though we have these broad rules and these extensions of time, I am hearing that judges and law enforcement, prosecutors and public defenders are all trying to still meet the constitutional and statutory requirements if they can. So even though we have rules that give more time, everyone is still operating under the greatest sense of urgency.
Well, Chief Justice Cantil-Sakauye, we know how busy you are. Thank you for your time, how busy all of us are, but you in particular have been generous to the council as a trustee. Thank you for that. And again, hope you stay safe and well in California.
Thank you. Thank you all. Thank you. It's also so great to see so many of, again, my panelists. Thank you very much. Nice to see you. Best wishes.
Thanks again. Well, from the Chief to Justice, but I want to introduce our panel before we go to you first, Justice Boggs. Justice Mike Boggs is first, the Georgia Supreme Court Justice there as well, and also the chair of the CSG's Justice Center Board of Directors, former colleague of mine there. We served together. We'll also have Laurie Dudgeon, another colleague of mine from Kentucky, longtime AOC director, also a National Center for State Courts board member. And by the way, so many of our panelists serve on too many boards and commissions to list, but please, again, visit their bios on our event page. Melissa Nelson is also a council trustee, state attorney for the 4th Judicial Circuit, that's the Jacksonville area, multiple state national boards. Would like to mention she established Florida's first conviction integrity review unit. I think that's very notable. And Keir Bradford-Grey, the chief defender for the Defender Association of Philadelphia. president also of the American Council of Chief Defenders. So welcome all of you. We'll get to what we hope will be a brisk back and forth, a number of questions, hopefully keeping things kind of running back and forth with a good, honest and candid discussion of all the issues that were teed up so nicely by the chief there. Mike, I'm sorry, Justice, I've known you as Mike for too long, and he's disappeared. There he is, man. That's magic. That background is impressive, Justice.
Like that.
Tell us a little bit about what's going on in Georgia. I know it's a different. You're unified, but not so unified. But tell us about what's going on there and how you've handled some of your biggest COVID-19 challenges.
So unlike California, and thank you, John, I appreciate the opportunity to join you, and I'm really appreciative for the opportunity to try to explain just the differences that we have across the United States about how the judiciary is engaged in combating the virus and the issues that are attributable to it. Unlike California, where their power apparently emanated from an order from the governor, Georgia's Supreme Court essentially has the authority to do three things that are important in this arena. First, we have a judicial emergency statute, which quite frankly gives us a broader authority, I think, than many high courts in their respective states. And so we have issued an emergency order, our Chief Justice has in this state, that largely suspends, tolls, extends statutes of limitations and periods of time that are important to litigants. The other authority that our court has that we've been relying on is our authority to regulate the practice of law. And as you know, we have state bars that are granted, examinations that are given every year, and we have to regulate the practice of law, and we have authority with the state bar to really help them expedite the approval of certain rules relative to the practice of law, and that's been very helpful. And then lastly, we have the authority to approve and ultimately approve all of the various classes of court rules pertaining to the operations of their court. And so those three silos of authority give our Chief Justice, Harold Melton, the authority to do a couple of things in our state that have been very helpful. We've issued an executive order declaring a statewide emergency, which has now been extended. And in short, as I alluded, that order by its own terms is fairly restrictive, but it is helpful in that it allows for statewide, unlike where California, you recall the Chief Justice just said that she had 58 counties where each county was declaring their own emergency and doing their own thing. We have 158 counties in Georgia, 159 counties in Georgia, and so we had the same problem with various classes of courts entering their own orders. So the Chief's order was very helpful to bring some uniformity to how our courts are dealing with these issues. But in short, the emergency statute only permits the extension, suspension, or tolling of certain periods of limitation. So for example, our order tolls the statute of limitations, time within which to appeal, time within which to issue warrants, time within which to try cases in which speedy trial demands have been made, times to hold committal hearings, times to return bills of indictment or file habeas petitions, times to complete discovery, and times to serve a party. And that's proven to be very helpful. The tolling of all of those periods will ensure that constitutional rights are protected. And then, so that's what we've done in the nature of our authority that emanated from statute.
Yeah, thanks, Mike. We'll come back to you. You know, Director Dudgeon, Laurie, I want you to touch on what the unified system means. And Kentucky is truly a unified system, and maybe some of the advantages or disadvantages that's created.
Well, I think, and John, thank you. Thank you for asking me to participate today. I'm honored. And I think there definitely are distinct advantages to being unified, but there are disadvantages as well. So we are very different than both California and Georgia. So we sort of present a third model, but as a unified court system, we are basically one budget with a significant amount of centralized authority in our Chief Justice and in our Supreme Court. So currently we are operating under a number of emergency orders, but that is through the constitutional authority vested in our Chief Justice. But as a unified court system, even though Kentucky is a rural state primarily, we do have 120 counties. We have over 406 elected judges, justices, and circuit court clerks across the state. And then we have over 3,500 employees in our unified court system. So, you know, in a lot of ways, we scale out to, you know, a large urban city somewhere else in the country. Some of our challenges are different. Fortunate in that we're centralized, we're able to roll this out pretty quickly, but we have a number of employees and elected officials who we couldn't get this done, I think, fast enough probably to support everybody. We're fortunate and that we're an Office 365 shop. We had a number of laptops already rolled out. We were utilizing video arraignment technology in a number of our jails already. So we were able to utilize an existing technology infrastructure and rely heavily on Skype for Business. Right off the bat, any place we didn't have our video arraignment system set up. That was one of our advantages. I think our disadvantage was we had never really used the technology before. We just had it available. So getting everybody trained and up to speed and implementing this in response to the Supreme Court's order was critical. The order that we're operating right now is basically, there are obviously exceptions, but the primary guidance from the court, we've evolved into what the order looks like right now, by the way. Our first order was March the 12th, and the court almost on a weekly basis is modifying that order and then extending its date through which it's effective. Right now we're effective through May 31st. But we've got mandatory video conferencing occurring. We're handling all of our emergency time-sensitive matters. It includes all of our domestic violence, our emergency custody orders, temporary child support, all of our in-custody arraignments, all of our preliminary hearings, our probation violations. We've done a number of additional things. Our judges have the discretion to hear anything else remotely they want to hear, but it's amazing. I think folks are probably working harder across the state right now to support everything we need to do to ensure access to justice and protect our court employees and the public through all the social distancing guidelines that have been issued. Some important additional things we've done, we've suspended all fines, fees, collections. Folks can still make payments online over the phone, but we're trying to minimize warrants that are issuing for failures to appear or failures to pay right now. That's been critical also. We've seen a great response from law enforcement and have been blessed with fabulous partners and stakeholders through our prosecutors and our public defenders here and all of our jailers statewide through their Jailers Association. So those are all the really good things that have happened for Kentucky, that and our judges and clerks' willingness to adopt this technology essentially overnight.
And Director, I want you to make a note. We'll come back. I know you've got some numbers as it relates to reduced jail pops, reduced arrest rates, things of that. So that's actually a perfect segue to turn to Ms. Nelson from what's going on in Florida. And I know you and I talked, and I think one of the things that stuck out to me was the steps, some of the extraordinary steps you've taken in collaboration with a number of those stakeholders that the Director mentioned to reduce your jail population and deal with sort of this balance between public safety and public health. And we need, Ms. Nelson, we need your audio. It's easy to mute yourself and then forget about it. It's happened only 100 or so times on these type calls this morning alone. So again, you're on there.
I think I'm unmuted now.
You are.
John, thank you for having me. It's nice to be on this panel today and to talk about this important issue. So one of my colleagues who is a prosecutor here, he's also a Rear Admiral in the Navy Reserves and trained in emergency preparedness and disaster response. He was the first person to actually bring this to our attention in mid-March, that the jail population, should we have a positive case, the potential for explosion in that population. And so he encouraged the office to put protocols in place to address the jail population, which to your point meant partnering with the jail, with the bench, as well as with the public defender's office. So we began with a written directive to the prosecutors in this office to begin conducting a self-review, a self-audit of all of their pending cases. That evolved over the course of a week into a written directive to all of the prosecutors in our office to address both pending prosecutions and prosecutions that I'll call in the pipeline, decisions to be made, in addition to those cases that were coming through first appearance. Once we actually issued the written directive, Admiral O'Keefe took lead in our office in getting all of the leadership in our office involved, and over the course of the next week, over the telephone, we called all of our prosecutors, our leadership did, and conducted telephonic conferences with all of them and reviewed all of their pending cases. To date, we've reviewed over 5,500 cases for what we consider expedited resolution. So where it was appropriate, and this obviously dealt with nonviolent offenders and nonviolent offenses, but where it was appropriate in first appearance to recommend a ROR, we did so. Where we could work cases out for time served, we did so. Any case where we had state offers of a year or less, we looked at, reviewed those for appropriate time served dispositions or probation dispositions. We've impacted through this endeavor, which has been going on since March 23rd, have directly impacted the jail population of 10%, reduced it. They are now under capacity. They're obviously very appreciative. We are very fortunate that we still have yet to have a positive COVID-19 case in the jail, but we were acting proactively. We actually had another lawyer in our office who had the good idea of standing up a disposition court. So while we were reducing our footprint throughout our court system, we did stand up a disposition of plea court in order for these cases that we had identified with the bench and the public defender's office and the private bar as well, that we could dispose of quickly. Our judiciary assisted us in making sure that we could cycle those cases through quickly. So those are some of the things that we've done. And I've found that the protocol has worked really well. And we've been tracking on the back end. I asked for the data set today on the back end, what in each of those categories, how we've impacted the jail population.
Excellent. I think you raised an issue too that I think Ms. Bradford-Grey can speak to. I know in Philadelphia, you and I talked about pressures. Oftentimes there is a give and take, and these pressures oftentimes mount on defendants in looking at these, again, plea agreements, which are necessarily being offered, as Ms. Nelson mentioned. How do you view those, and what do you think the issues are facing your clients across the country, but in Philadelphia in particular?
Thank you for that, and thank you for allowing me to join this wonderfully esteemed panel. Congratulations to all of you for being able to react very promptly in this time. What Ms. Nelson said raised a particular issue for the defense bar here in Philadelphia, and that's because we haven't yet had the structure and the technology to do hearings where we have both the person accused and the victim in the same proceeding. And so that has been hard for what we say right to confrontation. So we had to look at what could we do otherwise, and that has moved to the areas where we could agree for non-trial dispositions. Now here's the trick or the sticky part. Most of the times we've been arguing that most people who are in custody plea just to get out. And that is a reality in some areas. This is a little bit different because people are now pleading to get out because they know there's a pandemic that could have a rapid widespread, in which our prisons, it actually did spread rapidly once it hit. We were at a rate of about 15 to 20 per day positive cases. And so as we try to thin the prison population out to create more social distancing, we just couldn't contain the rate of release or the rate of positive cases that were happening. So people were now feeling the pressure to plead guilty to get out. And we did not know or want this to be a situation where we'd come back on us and say we've only pled guilty under duress situations. We're trying to find a medium or happy medium to deal with that for people who we can really look through their cases and understand the facts and the nature of their cases and get their agreement that they are doing this on their own volition, despite the fact that they are in a situation that is less than ideal, not just being incarcerated, but being incarcerated with a deadly virus going to hit. I don't know how that will stand up in a higher court if someone were to come back and say they did this under duress. That will be to be determined. But this is a situation where we're trying to balance the constitutional rights of individual, also trying to provide some flexibility, but also trying to make sure that we are moving people's cases along as they would have a right to be released if courts were open. We had some statistics drafted up so that it could guide us into our work. And, unlike any other jurisdiction, Pennsylvania is not a statewide system in terms of defense, public defense. Individual counties are left to their own decision-making. And so while our Supreme Court did issue an order to do hearings under emergency relief, that order did not give specific instruction on what to be doing. It kind of left it very broad for each population to deal with that on their own. So we started looking at our stats and figuring out who's in the jail, who's in the prison, also looking at whether or not their case, even if they were found guilty, their sentencing guidelines, so we go by sentencing guidelines in Pennsylvania, would it call for jail time? If that answer is no, then we were looking for emergency relief for people to be released pre-trial, while we worked with our community of supporters for programming, treatment options, and all of those other things that are not generally available for people on the front end, but more so on the back end and reentry. And so where people would be facing probation if they were convicted, we were looking to see if they could be released. That didn't always fall into these categories of low-level offending that people would think of in the outside world. We have case classifications that look pretty bad, say if it's a burglary, but there's variations within that that would call for reduced sentences. And that is the rub. It's the public perception and the narrative and the realities of what we see in this system in terms of the dangerousness or the dangerousness of an individual based on their charge. And so with that, we started looking through our cases. We started getting statistics and data together as far as how many people had cases that there's never been a complaining witness to show up. And in the ordinary course of business, these cases would be dismissed, because that is the reality of our systems, that every case that comes in doesn't necessarily go through a trial process or even a plea process. Some cases, a percentage of cases are actually dismissed because there's never a person that shows up to continue on with the prosecution. We had to look at that. We also had to look at people whose sentencing guidelines will call for probation. And we had to make some tough decisions on how to handle these, even though we have this imperfect situation where someone could come back and say, the only reason why I pled guilty is because I was afraid for my life in prison. And so these are the realities that we're dealing with. Despite that, we've been able to reduce our population through a number of avenues, through looking at people who can be released, who are on low-level bail, through looking at people who are on technical violations of probation where they have detainers lodged on them so that they didn't commit new crimes, but they just didn't follow the rules of probation, and figuring out, could those people be released so we can thin the population? Since we've closed in March 17, we've been able to reduce the population by 1,067 people. It has helped, but obviously it's still a prison situation where most social distancing cannot go on.
Yeah. What's the total population? You said you reduced it by 1,000 or so. What's the total population of the jail? What percentage is that?
So the percentage of reduction is about 18%. Now we still have people coming in because our police officers are still arresting those who are committing more violent crimes. So right now the total population when we started was 910, I'm sorry. And right now it's down to 910. Now some of them are not just because of our efforts. Some people were bailed out. They were given cash bail, and some people were transferred to other jurisdictions that could be released from Philadelphia.
Thank you for that. I'm going to turn back to the director now, Director Dudgeon, because I know you've got some numbers as it relates to the reductions in the jail populations across Kentucky. Again, I happen to know that system very well. So you got a number of jails, I think over 75 full service there across the state. What has been the reduction number? And touch on arrests as well before we ask the other panelists some of what they're seeing.
Our reduction numbers have been pretty dramatic. And as I mentioned before, it hasn't been because of one thing. It's been because of multiple stakeholder reaction. But our county jail population has reduced by more than 36%, which is just unheard of, I feel like, especially in Kentucky. One of the primary drivers, it's not only been, the Chief Justice reached out to our judges early, alerting them to the concern and crisis that would ultimately follow in our jails once the virus got into jail. As our executive director of our Jailer Association said, it's essentially game over if that happens. And that was enough, I think, for us to mobilize pretty quickly. Our judges have been outstanding almost universally across the board in Kentucky in trying to release folks. But one of the biggest drivers, I think, is our arrest data. When you look at our arrest data in Kentucky, on average, for 120 counties, we arrested approximately 700 people a day in the state. Our pretrial officers statewide interviewed those individuals. So we have the ability to access a lot of data. I know that a lot of state courts don't have, but we have a statewide pretrial database in addition to one trial court database. but we are now arresting on average about 175 people a day. Almost half those are misdemeanors, and half of those are approximately felonies. It's been dramatic how the arrests on the violent felony offenses has declined. And I know that there's a lot of different reasons for that. But I mean, for example, I had our pretrial officers pulled some data just on the 14th. And we pulled this data because that's the date that the court's new emergency release schedule went in place for pretrial defendants. We have operated under an administrative release program for low-level misdemeanors, nonviolent, non-sexual offenses since 2015. We've been operating under it statewide since 2017. The court took a bold step on Tuesday and expanded that to a number of additional offenses. In the first 24 hours that it was effective, we saw our release rates decline by more than 22%. So we have really tried to focus on pretrial release. I know some of our judges are taking some pleas, but it doesn't seem to be that we're taking a number of pleas right now. We're seeing some early releases on sentences already for the county inmate population, but the focus has really been to reduce this pretrial population to the extent we can. I was going to share, I think, on Tuesday, immediately before the order was effective, we only had 3 Class A felonies, John, arrested in Kentucky, and our population is about 4.4 million people. So it's dramatic what we're seeing happen right now. And I think I just want to mention that because I know there were initially some fears that folks had raised about public safety. Seeing a lot of folks truly are staying home. And it doesn't mean that it's not happening. I'm not saying that crime isn't occurring. I'm just saying it has dramatically reduced, at least in Kentucky.
That's interesting. I think it's probably worth noting, had a discussion with one of our panelists, Ms. Nelson. I'm going to turn to you next because I know that you see a little different situation there in the Jacksonville area. And I know despite some extraordinary efforts on your part, as you've described, and so many you won't describe today, but those on the call can find out with some research what you have done in collaboration with your partners. What are you seeing there with crime on the streets there?
So quite unfortunately, we're seeing something very different than you're seeing in your state in Kentucky. In our circuit in the city of Jacksonville, the violent crime, specifically gun crime, has increased significantly since the pandemic. We were beginning to see some downward trends, and we're experiencing the opposite right now. And so while our law enforcement partners are being very thoughtful about, in fact, who they're bringing to the back door of the jail, they are still arresting for violent offenses every single day. And I think I shared with you, John, on our preview call earlier, we have audio technology called ShotSpotter that captures gunfire in certain places in our city. And since it's been actually rolled out over the course of this quarter actually, but over the course of the last several weeks, we've had higher incidents of shots fired than since the inception of this technology. So we're experiencing quite the opposite. People, unfortunately, in certain areas in our city aren't staying at home. And I'll mention one last thing about our efforts. I talked about pending cases. We're also working hand in glove with the jail to identify for us those people who are nearing the end of their sentence, who are medically vulnerable, and we're working with the bench as well to initiate early release for people under sentence. So obviously our jail houses both people who are under sentence and people who are being held pretrial. We've developed strategies to hopefully reduce the populations of both of those sets of inmates.
That's fascinating. Again, I'm going to turn to you next, Justice Boggs. I know that while you may not have your thumb directly on some of the same things in a unified system that, for instance, Director Dudgeon and Chief Justice John Minton do there in his court, what have you seen in Georgia? I know you and I talked about what happened in one of your larger counties with the decrease in the jail pops there. And also I know that there's some work. I know our friend Mike Nail in probation and parole there in Georgia. Are you seeing something, that's notable there with regard to any of what you just heard commented on?
Yeah, I mean, I find it all very interesting. I will tell you that we started with the proposition in Georgia that, the authority of the Supreme Court in Georgia is limited. in large part by the statute under which we declare a judicial emergency, which in itself cabins our authority almost exclusively to timelines. And so as we move forward, we also don't have, like Kentucky, real-time crime data. So we don't have the arrest data that maybe a unified system might have. You know, I clearly recognize that prisons are a hard place and jails are a hard place to contain these issues. They're not unlike nursing homes. And so I know in Georgia, one of the things that we've done in our emergency order was, in addition to outlining that courts should continue with essential services, we actually defined what some of those essential services would be. And those definitions include making first appearance hearings, ensuring that we have delinquency detention hearings, but relative to this conversation, ensuring that we continue to provide prompt and efficient decisions on bail release decisions. For example, we've also changed court rules to permit that to be done by video conferencing. And so with our authority to adopt rules for classes of courts, I think that helps. We've seen anecdotally some jurisdictions in the state that have reduced their jail populations. At the end of March, we had roughly 37,700 people in jail in Georgia. Our county jails were at about 77% capacity. But of course, it's very hard to physically distance in a jail. And so the real question that I would ask, and I wonder if others are asking, is that the real issue is not how many you're releasing from jail. It's what is that release allowing you to do in that facility? Does that release allow you, for example, to reduce some of your staff, your non-essential staff, and get those folks out of that environment? Does it allow you to do medical quarantining in the county jail? Does it allow you to better and more efficiently engage in telehealth and telemedicine? I know we've seen some jurisdictions, large jurisdictions last week, maybe even earlier this week. DeKalb County, a large jurisdiction in Georgia, released over 100 misdemeanants. You know, we have a lot of people in Georgia that as a misdemeanant are entitled to bail. In many instances, low-risk nonviolent offenders that are charged with misdemeanants or misdemeanor crimes, they get a bail that they can't afford. And so I know that the courts in those jurisdictions are looking very hard at who can be released to as not adversely affect public safety. And so I will also say, I think that the conversation about pleas under these circumstances is obviously going to emanate its way up to the state's higher courts relative to the willingness and voluntariness of pleas. And I think that's a very astute observation. I've been concerned about that for some time, and we'll be anxious to see how that plays out. But I think what you're seeing in Georgia is that the parole board in Georgia, for example, I know is considering the early release, parole, if you will, of over 200 people that are in the state prison system that are within 6 months, 180 days of being released. And I know that they're making considerations for 300 more on top of those 200. And so there are conversations ongoing across the state. I think the challenge we have in Georgia, unlike maybe some other states, is managing people's expectations about what authority we actually have. And what authority we don't have. We cannot suspend, do not have the authority to suspend compliance with state law or compliance with the Constitution. And so we're trying to balance all of those concerns from a judicial standpoint, but we've had a very cooperative judiciary in our state, very cooperative prosecuting attorneys and defense attorneys councils that are being very helpful in helping this court fashion remedies that protect constitutional rights and protect the safety of the people that are in the criminal justice system. So those are some of the things we've been doing, John.
Thanks, Justice. You know, I may ask for the first one who could raise their hand on this, as I can see you all very well. You know, one of the issues I think that was sort of foretold or forecasted was the concern of the increase of potential domestic violence calls and incidents and just abuse scenarios. If any of you would care to comment on that, what you're seeing in your respective states or cities. Are you seeing an increase in those incidents? Anyone want to raise a hand and jump in? Director Dudgeon, do you know, given the reduction in arrest data, arrest rates, and admissions, and violent crime and felony crime, are you seeing an uptick in domestic violence calls?
Well, and honestly, John, that's what we were very concerned about, that we would see an increase in our DVOs and EPOs in the civil context. In Kentucky, those are civil claims. We are not seeing an increase in those arrests, fortunately. That's also data that we're tracking. But I've been relieved so far, and now it may be too early to tell, but that we haven't seen an increase in those filings in the civil context as well. We are taking those filings we e-file in all case types in all counties in the state, but those are still conventionally frequently a paper filed document. And it's something I probably need to mention. Our court system in Kentucky, all courthouses are, I would call, virtually open, but the doors are closed to foot traffic in the building unless it's an emergency and you're not able to access services either by picking up the phone or through email or some other way. Clerks are frequently taking pleadings in paper form out to parking lots so individuals can fill them out. I was probably most concerned about our EPOs and DVOs and have been relieved so far that we have not yet seen an uptick in those numbers, but I think it's going to depend on how long we live under the current circumstances too.
Yeah. You know, again, I'm going to turn to Ms. Bradford-Grey again. I know you touched on so many concerns with regard to your clients and the pressures they're under. Is there one thing that you're seeing from your position as chief defender there that that is significant to you? Is there a success with regard to collaboration that you may not have seen before in the midst of a crisis? Are people joining to make certain that justice is served, that public safety and public health can coexist?
Yeah, thank you for that question. I think what I'm seeing right now is something that we had hoped for before this, and that is to really look at pretrial decision-making and how we are looking at bail and release decisions. Are there alternatives to incarceration or to bail that we can utilize? And so what we have been able to do is we've been thinking about this, thank God, a few years before this happened. We've been able to put together a coalition of partners called our pre-entry coalition. So you know how we have re-entry, where we know that people need supports and help coming out, but pre-entry is where we start looking on the front end at the types of things people may need so that they don't have to sit in jail on low-level bail. And so we put that in place right now. And so as a result, we've been able to have a lot of people or a lot of programming available to us so that we can make decisions for pretrial release. And normally in Philadelphia, our jurisdiction, in Pennsylvania, we use bail as one of our first go-tos. It's bail, or if you're not, you know, even if your crime is not of any certain kind, you would just get released on your own recognizance. But those are the only real options that we had. Right now, we're putting together a much larger scale of options for people, and it seems to be working very well. It's keeping people supported, it's keeping prison populations down, but it's also doing something else, and it's allowing people to work on their issues so that when we come back, they may have things together enough so they don't have to get that lifetime criminal conviction.
No, thank you for that. And perfect timing. As promised, we're going to leave about 10 minutes for some Q&A from those who've submitted questions in our audience. And for that, I'm going to turn it back to our director and really chief of everything at the council, Abby Walsh.
Thanks so much, John, and thanks to all of our panelists for the wonderful discussion so far. We have great questions coming in from our listeners through the Q&A function, and there's a bit of a theme to some of these questions, and that's looking forward. So how are your systems beginning to plan to transition to a less socially distant reality? And are there any virtual practices that you've introduced that could turn out to be a positive for the court system generally and perhaps continue post-pandemic?
I'd say Ms. Bradford-Grey raised her hand first. Jump in, please.
I can say right now we are really looking at using virtual hearings for the non-trial or non-advocacy types of hearings that we have. We have a lot of appearances that are formal and formality, and we are really looking at the opportunity of using virtual hearings for those things so as to thin out how many people come into the Criminal Justice Center per day. We are doing that. The problem is, and I could say with public defender offices across the country, is that our technology has never been as robust as those of our other stakeholders. So trying to make sure that we have the ability to keep in line with the other stakeholders is going to be a challenge. I am fortunate that we have an office that has a wide range of technological support, but we are very much in the minority.
Anyone else want to chime in there? I see a couple of you. Justice Boggs, and then we'll go to Ms. Nelson.
Yeah, the technology challenges are clearly difficult, and I don't think anyone was quite ready for those. Georgia has 159 counties. We have 6 levels of trial courts. various resources available to rule in urban jurisdictions. That said, Georgia's Supreme Court on Monday, Tuesday, Wednesday, and Thursday of next week will be holding oral arguments via Zoom video. I'm not confident that that won't be something moving forward that at least is an available remedy for individuals who are unable to make it to the court. Georgia is a huge state geographically, and so I find just before this meeting, our court held bank our conferencing via Zoom for the third time. And so I think our courts also across the state, at the suggestion of the Chief Justice and as included in his emergency order, are moving toward more video conferencing where appropriate for bail release decisions. Those get complicated because we have a Victims' Bill of Rights that requires notification. We have constitutional obligations to keep courthouses open. And so trying to discern the best way to roll out technology with those competing concerns will be a challenge. But I do see our courts being very competent in doing that. And I've been real pleased with what I've seen, and I'm confident that it may provide an interesting way to do business moving forward for our appellate courts and our trial courts.
Ms. Nelson. Ms. Al, thanks, Justice.
I too would agree with what Justice Boggs has said. I look forward. I do think there has been a silver lining, at least for our operations. Necessity has forced our hand. We have a 3-year strategic plan, and we wanted our office to be paperless by the end of next year. And we went paperless in a matter of 3 weeks because we had to learn how to work remotely. And so I think we're an open discovery state. We're about to roll out a portal mechanism by which we will relay discovery. I think that will be something that will withstand this pandemic and be sustainable. As I think that several of the virtual technological tools that we're using in the courts.
Director? Yeah, thank you.
Sorry, I want to mention also, now I'm having to laugh at Justice Boggs because he knows I can't stop talking. Something that I want to mention too, what we're all going to face is a very significant real decline in state revenues for some time after this. We're all anticipating it here. We're starting even to prepare now to having, to begin making budget reductions. I think all this technology that suddenly everybody's had to essentially learn overnight is going to be a critical resource for us to use going forward to help save dollars in each of our budgets. So as my friend Jesse Rutledge at the National Center for State Courts said to me this morning, he said, this certainly isn't the crisis that any of our courts wanted, but it may have in fact been something that we needed if we were ever going to kick into this technology. And I want to use that as also as we talk about the technology, and I know Ms. Bradford-Grey mentioned also, we're all at different places in implementation, but I'm going to tell you, no matter how unsophisticated you may feel like your technology is, there's a solution out there that can work for you if you don't have this right now. So I would encourage everyone to maybe take a look at the National Center for State Courts, their website. They've hosted some webinars there that talk exactly about really some basic ways to utilize this technology. It's ncsc.org/pandemic. We have a CCJ acronym, and NCSC also, it's our Council of Chief Justices, and COSCA have established a rapid response team that has rolled a lot of resources out, and they have been mostly technology related resources. What's been interesting is that we have focused so many efforts, on the criminal justice side in our court system. Our civil attorneys are beating our doors down wanting to utilize the same technology. So we know that demand is going to continue once we're all fortunate enough to get through the other side of this pandemic.
I think you all hit all the proper notes there with those answers. Abby, do we have time for at least a couple of more questions, at least one in particular?
I think that we can fit one more question in here. And there's also been a theme in some of our questions related to victim services during this time, particularly with releases being expedited. How are some of your systems handling victim notification? Have there been any adjustments to that system during the COVID-19 response?
Yeah, I think Ms. Nelson right off the bat here. I know we talked about that.
So we have not, in our larger initiative for expedited resolution of cases, we have not agreed to disposition of a case or release of an inmate without victim notification. That is constitutionally and required in the state, and we've abided by that obligation. In addition to that, we put together a presentation we've just shortly before the pandemic, our court system rolled out an e-notification system that anybody interested in a case can take advantage and be notified by text of the status of court hearings. That was particularly important to us for victims and a dynamic court schedule over the course of however long this will last, that may be changing. And so all of our victim specialists in our office trained on how to educate and help victims become acquainted with e-notification and register and enrolled in it. And then we also did a remote working tool in our office and incorporated that information for all of our lawyers who may have contact with victims as well, to alleviate trying to pick up the phone and call them or letter correspondence. So it takes a little effort on the front end, but our office has now been trained how to use that, and we're keeping our crime victims abreast of what's going on with court proceedings that way.
To our other panelists, we have exactly 2 minutes left so we can end on time for everyone. Anybody have a quick response or follow up to that? Victim notifications, anyone?
I mean, I will, because this has been a source of controversy. I'm sorry, didn't someone else?
You did not. Go right ahead. We've got director. We can do it quickly.
This has been a source of controversy in Pennsylvania in terms of pretrial release. What qualifies as a victim when a person is not convicted yet? Our DA is trying to be as courteous as possible to people to let them know that we are doing this, but getting their consent for pretrial is not necessarily constitutionally mandated here in Pennsylvania. So it's been a little bit of a rub in terms of, public perception, but we do have to realize that there is a constitutional right to be presumed innocent. And so if we started to need victims' acceptance to release people pre-trial, even under this pandemic, which the victims' rights advocates have asked for that to happen, then we are going to really be in a situation where this is not constitutionally required, and it's rubbing against the constitutional rights of a person who is presumed innocent.
30 seconds, Director Dudgeon, and we'll close it out. Thank you.
Through a partnership with our Department of Corrections, we host a victim notification system on our website that folks can sign up for anytime there's any change in their defendant's status in either the corrections system or if they're post-adjudication in our jails. And I know Ms. Bradford-Grey mentioned that. Very, very different than in the pretrial context, I think, with respect to victim notification. It is a different constitutional question.
Well, we want to thank an incredible group of panelists. Thank you all. Thank you to our listeners and those who tuned in and watched and listened as well. Thank you for your leadership in the field. Hope everyone stays safe and healthy, of course. Please stay tuned for our next call in this series. Also, a video and summary of this event and all of our Facing COVID-19 events will be available on our website soon. And be sure to join our mailing list and follow us on social media to hear what's next, as I said, in this timely series. And again, most of all, please, again, stay safe and healthy. Thank you so much for joining us today.